Please be seated. The sitting is open. The Court meets in this public sitting to deliver its decision on the request for the indication of provisional measures submitted by Armenia in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. For reasons duly made known to me, Judges Tomka, Benuna, and Shui, who duly participated in the deliberations and the final vote in this case, are unable to sit with us this afternoon. I recall that on 16 September 2021, Armenia filed in the registry of the court an application instituting proceedings against Azerbaijan concerning alleged violations of the International Convention on the Elimination of All Forms of Racial Discrimination of 21 December 1965, which I shall refer to as CERD or the Convention. The application contained a request for the indication of provisional measures submitted with reference to Article 41 of the statute and to Articles 73, 74, and 75 of the Rules of Court, which is referred to in today's order as the first request. By an order of 7 December 2021, the Court indicated the following provisional measures, I quote, 1. The Republic of Azerbaijan shall, in accordance with its obligations under the International Convention on the Elimination of All Forms of Racial Discrimination, A. Protect from violence and bodily harm all persons captured in relation to the 2020 conflict who remain in detention and ensure their security and equality before the law. B. Take all necessary measures to prevent the incitement and promotion of racial hatred and discrimination, including by its officials and public institutions, targeted at persons of Armenian national or ethnic origin. C. Take all necessary measures to prevent and punish acts of vandalism and desecration affecting Armenian cultural heritage, including but not limited to churches and other places of worship, monuments, landmarks, cemeteries, and artifacts. And 2. Both parties shall refrain from any action which might aggravate or extend the dispute before the court or make it more difficult to resolve. End of quote. I also recall that by a letter dated 16 September 2022, Armenia, referring to Article 76 of the Rules of Court, requested the modification of the court's order of 7 December 2021. By an order dated 12 October 2022, the court found that, I quote, the circumstances as they then presented themselves to the court were not such as to require the exercise of its power to modify the measures indicated in the order of 7 December 2021. End of quote. In addition, the court reaffirmed the provisional measures indicated in its order of 7 December 2021, in particular, the requirement that both parties refrain from any action which might aggravate or extend the dispute before the court or make it more difficult to resolve. On 28 December 2022, Armenia, referring to Article 41 of the statute and Article 73 of the Rules of Court, filed a new request for the indication of provisional measures, and on 26 January 2023, it communicated to the court the text of a further provisional measure sought. This request is referred to in today's order as the third request. By an order dated 22 February 2023, the court indicated the following provisional measure, I quote, the Republic of Azerbaijan shall, pending the final decision in this case and in accordance with its obligations under the International Convention on the Elimination of All Forms of Racial Discrimination, take all measures at its disposal to ensure unimpeded movement of persons, vehicles, and cargo along the Lachen corridor in both directions. End of quote. I further recall that on 15 May 2023, Armenia, referring to Article 76 of the Rules of Court, requested the modification of the court's order of 22 February 2023. By an order dated 6 July 2023, the court found that the circumstances as they presented themselves to the court at that time were, I quote, not such as to require the exercise of its power to modify the order of 22 February 2023, indicating a provisional measure, end of quote, and reaffirmed the provisional measure indicated in its order of 22 February 2023. I finally recall that on 28 September 2023, Armenia filed a new request for the indication of provisional measures, referring to Article 41 of the statute and Article 73 of the Rules of Court. This request is the subject of today's order and is referred to therein as the fifth request. In this request, Armenia states that on 19 September 2023, Azerbaijan, I quote, launched a full-scale military assault on the 120,000 ethnic Armenians of Nagorno-Karabakh, indiscriminately shelling the capital, Stepanakert, and other civilian settlements, end of quote. It adds that the attack killed and wounded hundreds of people, including civilians, and that tens of thousands of ethnic Armenians have been forcibly displaced from Nagorno-Karabakh to Armenia. In accordance with the usual practice, I shall not read out the introductory paragraphs of the order, which set out the procedural history of the case. I shall omit or summarize some other paragraphs. I shall accordingly begin reading the order at paragraph 27. The full text of the order will, of course, be available at the close of the sitting. The Court begins by recalling that, pursuant to Article 76, paragraph 1 of the Rules of Court, a decision concerning provisional measures may be modified if, in the Court's opinion, I quote, some change in the situation justifies such a modification, end of quote. According to Article 75, paragraph 3 of the Rules of Court, I quote, the rejection of a request for the indication of provisional measures shall not prevent the party which made it from making a fresh request in the same case based on new facts, end of quote. The same applies when additional provisional measures are requested. It is therefore for the Court to satisfy itself that the fifth request by Armenia is based on new circumstances, such as to justify it being examined. The Court notes that in its fifth request, Armenia makes allegations of a forced displacement of persons of Armenian national or ethnic origin following a military assault against them by Azerbaijan. The Court recalls that Armenia's first request related to the treatment by Azerbaijan of Armenian prisoners of war, hostages, and other detainees in its custody who were taken captive during the September to November 2020 hostilities and in their aftermath, to the alleged incitement and promotion by Azerbaijan of racial hatred and discrimination targeted at persons of Armenian national or ethnic origin, and to the alleged harm caused by Azerbaijan to Armenian historic, cultural, and religious heritage. In its third request, Armenia referred to the alleged blockade by Azerbaijan as of 12 December 2022 of the Lachin corridor. In light of the foregoing, the Court considers that the circumstances underlying Armenia's present request differ from those on the basis of which the Court indicated provisional measures on 7 December 2021 and 22 February 2023. It follows that there are new circumstances that justify the examination of Armenia's fifth request. With respect to the question of prima facie jurisdiction, the Court recalls that in its order of 7 December 2021, indicating provisional measures in the present case, it concluded that prima facie it had jurisdiction pursuant to Article 22 of CERD to entertain the case to the extent that the dispute between the parties relates to the interpretation or application of the Convention. It reiterated that conclusion in its order of 22 February 2023. The Court sees no reason to revisit this conclusion for the purposes of the present request. The Court then recalls that its power to indicate provisional measures under Article 41 of the statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits. It follows that the Court must be concerned to preserve by such measures the rights which may be subsequently adjudged to belong to either party. Therefore, the Court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. At this stage of the proceedings, however, the Court is not called upon to determine definitively whether the rights which Armenia wishes to seek protected exist. It need only decide whether the rights claimed by Armenia on the merits and for which it is seeking protection are plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. The Court notes that CERD imposes a number of obligations on states parties with regard to the elimination of racial discrimination as defined in Article 1, Paragraph 1 of that Convention. In accordance with Article 2, Paragraph 1 of that convention, states parties, I quote, condemn racial discrimination and undertake to pursue, by all appropriate means and without delay, a policy of eliminating racial discrimination in all its forms, end of quote. Under Article 5, states parties undertake to guarantee the right of everyone, without distinction as to race, color, or national or ethnic origin, to equality before the law, notably in the enjoyment of rights listed in that article. The Court notes that Articles 2 and 5 of CERD are intended to protect individuals from racial discrimination. It recalls, as it did in past cases in which Article 22 of CERD was invoked as the basis of its jurisdiction, that there is a correlation between respect for individual rights enshrined in the Convention, the obligations of states parties under the Convention, and the right of states parties to seek compliance with those obligations. A state party to CERD may invoke the rights set out in Articles 2 and 5 only to the extent that the acts complained of constitute acts of racial discrimination as defined in Article 1 of the Convention. In the context of a request for the indication of provisional measures, the Court examines whether the rights claimed by an applicant are at least plausible. In the fifth request, Armenia claims that an attack by Azerbaijani forces on 120,000 persons of Armenian ethnic origin led to a forcible displacement of tens of thousands of such persons from Nagorno-Karabakh to Armenia. Articles 2 and 5 of CERD protect rights including the right to be free from racial discrimination and the right to equality before the law in the enjoyment of the right to security of person and protection by the state against violence or bodily harm, of the right to freedom of movement and residence within the border of the state, and of the right to leave any country, including one's own, and to return to one's country. In light of these rights, the Court finds plausible the right of persons not to find themselves compelled to flee their place of residence for fear that they will be targeted because they belong to a protected group under CERD, and the right of those persons to be guaranteed a safe return. On the basis of the information presented to it, the Court considers plausible at least some of the rights asserted by Armenia that it claims to have been violated in the aftermath of the operation commenced by Azerbaijan in Nagorno-Karabakh on 19 September 2023. The Court then turns to the condition of the link between the rights claimed by Armenia and the provisional measures requested. The Court considers that a link exists between the rights claimed by Armenia that are plausible under CERD and certain measures requested by Armenia. In particular, a link exists between those rights and the measures directing Azerbaijan to prevent the displacement of the remaining persons of Armenian national or ethnic origin from Nagorno-Karabakh, to ensure the right of those persons displaced to a safe return of their home, and to permit those who wish to leave Nagorno-Karabakh to do so without any hindrance. The Court also considers that a link exists between those rights and the requested measure with respect to civil registers, identity documents, and property titles and registers. The Court concludes, therefore, that a link exists between certain rights claimed by Armenia and some of the requested provisional measures. The Court next notes that pursuant to Article 41 of the statute, it has the power to indicate provisional measures when irreparable prejudice could be caused to rights which are subject of judicial proceedings or when the alleged disregard of such rights may entail irreparable consequences. However, the power of the Court to indicate provisional measures will be exercised only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the Court gives its final judgment. The condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment before the Court makes a final decision in the case. The Court must therefore consider whether such risk exists at this stage of the proceedings. The Court is not called upon, for purposes of its decision on the fifth request, to establish the existence of breaches of obligations under CERD, but to determine whether the circumstances require the indication of provisional measures for the protection of rights under this instrument. It cannot at this stage make definitive findings of fact, and the right of each party to submit arguments in respect of the merits remains unaffected by the Court's decision on the fifth request. The Court observes that the operation commenced by Azerbaijan in Nagorno-Karabakh on 19 September 2023 took place in the context of a long-standing exposure of the population of Nagorno-Karabakh to a situation of vulnerability and social precariousness. As the Court has already noted, the residents of this region have been severely impacted by the long-lasting disruption of the connection between Nagorno-Karabakh and Armenia via the Lachen corridor, which has impeded the transfer of persons of Armenian national or ethnic origin hospitalized in Nagorno-Karabakh to medical facilities in Armenia for urgent medical care. There have also been hindrances to the importation into Nagorno-Karabakh of essential goods, causing shortages of food, medicine, and other life-saving medical supplies. The Court further observes that, according to United Nations reports, more than 100,000 persons of Armenian national or ethnic origin have found themselves compelled to leave their place of residence and reach the Armenian border since the operation commenced by Azerbaijan in Nagorno-Karabakh on 19 September 23, after which Azerbaijan regained full control over Nagorno-Karabakh. The Court considers that persons of Armenian national or ethnic origin who are present in Nagorno-Karabakh and those who have left the region remain vulnerable. With respect to the persons of Armenian national or ethnic origin who are still residing in Nagorno-Karabakh, the Court recalls its previous statement that irreparable prejudice can be caused to the right to equality before the law in the enjoyment of the right to freedom of movement and residence within a state's borders when the persons concerned are exposed to privation, hardship, anguish, and even danger to life and death. The Court has also considered that a prejudice can be considered as irreparable when individuals are subject to temporary or potentially ongoing separation from their families and suffer from psychological distress, or when students are prevented from pursuing their studies. The Court has recognized that individuals forced to leave their own place of residence without the possibility of return could be subject to a serious risk of irreparable prejudice. It is of the view that similar considerations apply to the persons of Armenian national or ethnic origin who found themselves compelled to flee their place of residence for fear that they will be targeted because they belong to a protected group under CERD. In view of the relationship between the rights of the aforementioned individuals and the rights of states parties to the Convention, it follows that there is also a risk of irreparable prejudice to the rights asserted by the applicant. In light of these considerations, the Court concludes that disregard for the rights deemed plausible by the Court could cause irreparable prejudice to those rights, and that there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused before the Court makes a final decision in the case. The Court observes that these conclusions regarding the risk of irreparable prejudice and urgency must be considered in light of the formal undertakings made by the agent of Azerbaijan on behalf of his government at the public hearing that took place on the afternoon of 12 October 2023. I quote, A. Azerbaijan undertakes to do all in its power to ensure, without distinction as to national or ethnic origin, A. the security of residents in Karabakh, including their safety and humanitarian needs, including through 1. the provision of food, medicines, and other essential supplies to Karabakh, 2. providing access to available medical treatment, and 3. maintaining the supply of public utilities, including gas and electricity. The right of residents to Karabakh to freedom of movement and residence, including the safe and prompt return of those residents that choose to return to their homes, and the safe and unimpeded departure of any resident wishing to leave Karabakh. And C, the protection of the property of persons who have left Karabakh. Armenia also undertakes to facilitate A, the access and activities of the ICRC, with whom Azerbaijan undertakes to cooperate in order to ensure the provision of humanitarian aid in Karabakh, and inspections of the United Nations, such that it is able to make visits to Karabakh to advise on measures to address humanitarian, socioeconomic, and other needs in Karabakh. C, Azerbaijan undertakes to protect and not to damage or destroy cultural monuments, artifacts, and sites in Karabakh. And finally, D, Azerbaijan undertakes to protect and not to destroy registration, identity, and/or private property documents and records found in Karabakh. End of quotation. The Court recalls that unilateral declarations can give rise to legal obligations, and that interested states may take cognizance of unilateral declarations and place confidence in them, and are entitled to require that the obligation thus created be respected. The Court further recalls that once a state has made such a commitment concerning its conduct, its good faith in complying with that commitment is to be presumed. The Court notes that the undertakings of the agent of Azerbaijan, which were made publicly before the Court and formulated in a detailed manner, are aimed at addressing the situation of persons of Armenian national or ethnic origin in Nagorno-Karabakh following the operation commenced by Azerbaijan in this region on 19 September 2023. The Court is of the view that the undertakings made by the agent of Azerbaijan on behalf of his government are binding and create legal obligations for Azerbaijan. The Court observes that many of Azerbaijan's undertakings address the concerns expressed by Armenia in its fifth request, although the undertakings do not correspond in all respects to the measures requested by Armenia. This is the case in particular for Armenia's requested measure regarding the situation of persons of Armenian national or ethnic origin in Nagorno-Karabakh who do not wish to leave Nagorno-Karabakh but may feel compelled to do so if, I quote, actions directly or indirectly aimed at or leaving or having the effect of displacing the remaining ethnic Armenians from Nagorno-Karabakh, end of quotation, were to be taken. In the view of the Court, the undertakings made by the agent of Azerbaijan at the public hearing in the afternoon of 12 October 2023 contribute towards mitigating the imminent risk of irreparable prejudice resulting from the operation commenced by Azerbaijan in Nagorno-Karabakh on 19 September 2023, but do not remove the risk entirely. In light of these considerations, the Court finds that even taking into account the undertakings made by the agent of Azerbaijan on behalf of his government at the public hearing on the afternoon of 12 October 2023, irreparable prejudice could be caused to the rights invoked by Armenia, and there is still urgency in the sense that there is a real and imminent risk of irreparable prejudice to those rights before the Court gives its final decision. The Court concludes from all of these considerations that the conditions for the indication of provisional measures are met. It is therefore necessary, pending its final decision, for the Court to indicate certain measures in order to protect the rights claimed by Armenia as identified by the Court. The Court recalls that it has the power under the statute, when a request for provisional measures has been made, to indicate measures that are in whole or in part other than those requested. In the present case, having considered the terms of provisional measures requested by Armenia and the circumstances of the case, the Court finds that the measures to be indicated need not be identical to those requested. The Court concludes that, with regard to the situation described in the order, pending the final decision in the case, Azerbaijan must, in accordance with its obligations under CERD, 1. Ensure that persons who have left Nagorno-Karabakh after 19 September 2023 and who wish to return to Nagorno-Karabakh are able to do so in a safe, unimpeded, and expeditious manner. 2. Ensure that persons who remained in Nagorno-Karabakh after 19 September 2023 and who wish to depart are able to do so in a safe, unimpeded, and expeditious manner. And 3. Ensure that persons who remained in Nagorno-Karabakh after September 1923 or returned to Nagorno-Karabakh and who wish to stay are free from the use of force or intimidation that may cause them to flee. The Court also recalls Azerbaijan's undertaking, I quote, to protect and not to destroy registration, identity, and/or private property documents and records found in Karabakh, end of quote. In this regard, the Court considers it necessary for Azerbaijan also to have due regard in its administrative and legislative practices to such documents and records that concern persons who have left Nagorno-Karabakh after 19 September 23 and who wish to return to Nagorno-Karabakh, persons who have remained in Nagorno-Karabakh after that date, and persons who returned to Nagorno-Karabakh and who wish to stay. In view of the specific provisional measures that it has decided to indicate, and in light of the undertakings made by the agent of Azerbaijan at the public hearing that took place on the afternoon of 22 October 2023, the Court considers that Azerbaijan must submit a report to the Court on the steps taken to give effect to the provisional measures indicated and to the undertakings made by the agent of Azerbaijan within 8 weeks as from the date of this order. The report so provided shall then be communicated to Armenia, which shall be given an opportunity to submit to the Court its comments thereon. The Court reaffirms the provisional measures indicated in its orders of 7 December 2021 and 22 February 2023. The Court further reaffirms that the decision given in the present proceedings in no way prejudices the question of the jurisdiction of the Court to deal with the merits of the case, or any questions related to the admissibility of the application or to the merits themselves. It leaves unaffected the right of the governments of Armenia and Azerbaijan to submit arguments in respect of those questions. I shall now read out the operative part of the order. For these reasons, the Court indicates the following provisional measures. 1. By 13 votes to 2, the Republic of Azerbaijan shall, in accordance with its obligations under the International Convention on the Elimination of all forms of racial discrimination, 1. Ensure that persons who have left Nagorno-Karabakh after 19 September 2023 and who wish to return to Nagorno-Karabakh are able to do so in a safe, unimpeded, and expeditious manner. 2. Ensure that persons who remained in Nagorno-Karabakh after 19 September 2023 and who wish to depart are able to do so in a safe, unimpeded, and expeditious manner. And 3. Ensure that persons who remained in Nagorno-Karabakh after 19 September 23 or returned to Nagorno-Karabakh and who wish to stay are free from the use of force or intimidation that may cause them to flee. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Benuna, Shway, Sabatinde, Bandari, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Dode. Against, Judge Youssef, Judge Ad hoc Karoma. By 13 votes to 2, the Republic of Azerbaijan shall, in accordance with its obligations under the International Convention on the Elimination of all forms of racial discrimination, protect and preserve registration, identity, and private property documents and records that concern the persons identified under subparagraph 1, and have due regard to such documents and records in its administrative and legislative practices. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Benuna, Shway, Sabatunde, Bandari, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Dode. Against, Judge Youssef, Judge Ad hoc Karoma. 3. By 13 votes to 2, the Republic of Azerbaijan shall submit a report to the Court on the steps taken to give effect to the provisional measures indicated and to the undertakings made by the agent of the Republic of Azerbaijan on behalf of his government at the public hearing that took place on the afternoon of 12 October 2023, within 8 weeks as from the date of this order. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Benuna, Shway, Sabatunde, Bandari, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Dode. Against, Judge Youssef, Judge Ad hoc Karoma. I shall now call on the Registrar to read the operative part of the order in French.
Par ces motifs, la Cour indique à titre provisoire les mesures conservatoires suivantes. 1. Par 13 voix contre 2, la République d'Azerbaïdjan doit, conformément aux obligations qu'elle tient de la Convention internationale sur l'élimination de toutes les formes de discrimination raciale, petit 1, veiller à ce que toute personne qui aurait quitté le Haut-Karabakh après le 19 septembre 2023 et qui souhaiterait y retourner soit en mesure de le faire en toute sécurité, librement et rapidement. Petit 2, veiller à ce que toute personne qui serait restée au Haut-Karabakh après le 19 septembre 2023 et qui souhaiterait en partir soit en mesure de le faire en toute sécurité, librement et rapidement. Et, petit 3, veiller à ce que toute personne qui serait restée au Haut-Karabakh après le 19 septembre 2023 ou qui y serait retournée, qui souhaiterait y rester, ne fasse pas l'objet de recours à la force ou d'intimidation susceptibles de l'inciter à fuir. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka Bennouna, Mesdames Choué Sebutinde, Messieurs Bandari Salam Iwasawa Nolt, Madame Charlesworth, Monsieur Brandt, juge, Monsieur Daudet, juge ad hoc. Contre Monsieur Youssouf, juge, Monsieur Koroma, juge ad hoc. 2. Par 13 voix contre 2, la République d'Azerbaïdjan doit, conformément aux obligations qu'elle tient de la Convention internationale sur l'élimination de toutes les formes de discrimination raciale, protéger et préserver les documents et registres liés à l'enregistrement, à l'identité et à la propriété privée relatifs aux personnes désignées au point 1 et en tenir dûment compte dans sa pratique administrative et législative. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka Bennouna, Mesdames Choué Sebutinde, Messieurs Bandari, Salam, Iwasawa, Nolt, Madame Charlesworth, Monsieur Brand, juge, Monsieur Daudet, juge ad hoc, contre Monsieur Youssouf, juge, Monsieur Koroma, juge ad hoc. 3. Par 13 voix contre 2, la République d'Azerbaïdjan doit présenter à la Cour un rapport sur les dispositions qu'elle aura prises pour donner effet aux mesures conservatoires indiquées, ainsi qu'aux engagements pris par son agent, en son nom, lors de l'audience publique qui s'est tenue l'après-midi du 12 octobre 2023, dans un délai de 8 semaines à compter de la date de la présente ordonnance. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka Bennouna, Mesdames Choué Sebutinde, Messieurs Bandari, Salam, Iwasawa, Nolt, Madame Charlesworth, Monsieur Brand, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Youssouf, juge, Monsieur Koroma, juge ad hoc.
Judge Youssouf appends a dissenting opinion to the order of the court. Judge ad hoc Koroma appends a dissenting opinion to the order of the court. The text of the order is available from today in TypeScript. It will be available shortly on the court's website. The printed text will be available in due course. As the court has no further business before it today, I declare the sitting closed.